So today I'm going to actually start the next unit, Unit 9 on employment law. You don't have anything due this week for employment law. It's going to be due on the following Monday, the 27th. You do have a quiz due for Unit 8, which is what we did on Tuesday. It was just a one-class unit. We got through it in one day. You have a short quiz for product liability that's due this coming Monday, the 20th. We will not do any units after employment law. So I'm going to do employment law today and then both classes next week. And then that'll be it for our new content. That final week of class, we will review for the exam. The exam is take home. It is reflective. It is cumulative in the sense that it does cover the whole semester, but it is not cumulative in the sense that I'm not giving you an exam with the same questions you've already had so far. So you'll have 8 or 9 days of which to do that exam at your own pace whenever it's convenient for you. You need to remember that your career prep is due Friday the 24th. And then by Friday the 24th, you also need to have all your discussion questions answered. Yes? It's all writing response answering questions. Yep. And I'm going to give you the questions ahead of time because I want you to be thinking about them. It's not designed to be tricky at all. It's just really designed for me to kind of gauge what you got from the class, which I hope is something worthwhile. Any other questions about where we are? All right, so if there are no other questions, then we will start on employment law. Make sure it's recording. All right, so this is probably, I think, one of the more practical, useful things that we'll cover in this class. You'll run into employment law issues, whether or not you are the employee or the employer. They're pretty wide-ranging. Employment law as a whole is covered by state law, but also federal law, probably mostly federal law, but every state is able to add their layer of employment law on top of what the federal government provides. So the way it works is federal statutes govern employment. States cannot pass laws that are contrary to the federal employment laws. They cannot dilute or make exceptions to federal employment laws. They can make them stronger. They can go over and above what the federal employment laws require. For example, minimum wage. Anybody know what the federal minimum wage is? $7.25, right? So a state cannot go below $7.25, which would almost be laughable. The minimum wage hasn't changed in years and years. But states are free to pass laws that would increase the minimum wage above the federal minimum. And many, many have done so, which we'll talk about in a minute. So that's kind of the structure of employment law. It is affected by federal and state law. But federal law kind of provides the baseline. The default rule when it comes to employment law is an idea called at-will employment. We're going to spend a lot of time after I explain at-will employment talking about all the exceptions to at-will employment. But the baseline is that in an at-will employment situation, an employer is free to hire or fire for any reason. Okay, now if that sounds funny to you, it's because, no, wait a minute, what about discrimination? What about disability? Those are exceptions, which we're going to spend a lot of time on. But the general default rule is at-will employment means that you can be hired or fired at will, at the discretion of the employer. If at my law office, I have one employee, if if I decide to walk in after class today and fire her because she gets on my nerves, I can do that. She's an at-will employee. If I walk in and I don't like the way her perfume smells, I can fire her. She's an at-will employee. Okay. Now society, states, governments, federal governments have spent a lot of time carving out exceptions to the at-will rule, which there are many. One exception is through contract law. If an employee has a contract for employment with the employer, then that employee is not at will. That employee's employment, the terms of that employee's employment are governed by the contract that they've entered into. Okay? I sign a contract on a yearly basis with CSU. So I'm not an at-will employee. The dean can't come in here and fire me just because she doesn't like the pullover that I'm wearing, which she could do if I was at will. All right, so my employment contract with the University System of Georgia spells out the terms and conditions of my employment, how much I get paid, what I'm required to do, the reasons why I could be fired. All right, another exception to at-will employment is if a state or a federal government has passed any law making discrimination illegal. And they have. The federal government has passed many anti-discrimination statutes. And some states have passed additional anti-discrimination laws that go over and above what the federal law is. We're going to spend a lot of time later today talking about, if we get to it today, talking about federal and state anti-discrimination statutes. I'm bringing them up now just to show you that that is an exception to the at-will doctrine. Your outline talks about how some courts have accepted the idea that there is an implied contract between an employer and employee. An implied contract, if you remember from our contracts discussion, means that the contract is implied from the circumstances, from the actions, from the expectations, not from something that is written or reduced to an actual written hard contract form. I would not be comfortable if I was an employee betting my case on an implied contract theory, right? That would be something I would probably use if I didn't have anything else to go on. If I'm an employee and I'm worried about my employment status, I'm going to nail that down with my employer in a written contract. Not going to rely on some implied contract theory. It's not very commonly accepted by the courts. Another exception to at-will employment is that an employer cannot fire an employee for refusing to do something illegal. Okay? For refusing to break the law. A person cannot be fired for being a whistleblower, which is the word that's used to refer to an employee who turns in their employer for doing something illegal. All right, so those are all exceptions to the at-will employment doctrine. Some states have passed laws making it illegal to fire employees or refuse to hire employees for certain reasons that don't fall within anti-discrimination statutes. We call that wrongful discharge. So in other words, sometimes you might have a state that says an employer has to have a good reason for firing an employee. That's another way of getting around the at-will employment default doctrine. Okay. Let's talk about for a second federal laws that govern wages, hours, and leave. So your outline talks about some important federal statutes that govern wages and hours. I'm not going to ask you on any quiz the names of these statutes. It's not important. I do want you to know the general idea that the federal government sets minimum wages. They set the rules for overtime. They set rules for how old you have to be to work in certain areas. So minimum wage we talked about already. $7.25 is the federal floor. Every state is welcome to pass laws that require minimum wages higher than that. They just can't go lower. Does anybody know what the highest minimum wage is right now? Say it again. It's higher than 15. I actually looked at it. I Googled it this morning because I was curious. Washington State is $17 or $16.90. It's close to 17. Okay, there you go. And then my Google response this morning also said that some cities in, I think, Seattle and some cities in California actually have minimum wages higher than what their state requires. So Seattle may even be even higher. I think Washington, I think I said that wrong. Washington, D.C. is 17, but Washington State is also pretty high up there. I think Seattle may be, somebody can Google it, but I think Seattle may be the highest. I don't know, but it's a very different than $7.25, right? So a lot's been happening in federal law with wages and hours, not necessarily with minimum wage at the federal level, but you are familiar, y'all are probably personally familiar with the effect of your taxes this year on tips, right? Those used to be subject to taxation, income tax, and now they're not. Anybody, is anybody compensated in their job through tips? Kinda. You have so sometimes if you're tipped, if tips are part of your compensation, your employer can actually go lower on minimum wage because of your tips. And I'm not asking you how much you make, but is tips factored into how much you make?
Yeah, so I have my base pay and then whatever we make on tips.
Base plus tips. All right. So yesterday was tax day. If you filed your taxes, you would not have had to pay taxes on any tips. So I'm betting that your W-2 for last year looked different than it did in previous years. They had to split out your tip or your non-taxable income from your base. Is that right? I haven't seen one, so I'm guessing on this.
So that means that the base now goes up. Years ago, when I worked at Country, it was 213.
That was your base and then plus tips. So I don't know the exact rules for what the base, how it works with base and tips. I know generally that they can go lower than minimum wage, but because they factored in the tips. But did it, Jordan, make a difference? Did you know? Was it a noticeable difference for you this year in your taxes?
Yeah, slightly.
Good. Okay, good. That's good to hear. Whenever we have stuff like that, I always like to know that it had the actual impact that everybody says it's supposed to have. So good. All right, so that's minimum wage. Overtime. Anybody here personally familiar with overtime? Overtime is good and bad. Overtime is not good in the sense that you're working over 40 hours a week. Overtime is good in the sense that your paycheck really gets bumped up when you get overtime. The new tax laws are that overtime is not taxable anymore, right? Has anybody had any experience with that presently? I'm wondering exactly how that works. I'm guessing that is your whole overtime pay exempt from taxes, or is it just the amount that's in excess of your salary? I don't know. The way overtime works is that if you work any hours over 40, every hour above 40, you're paid 1.5 times your hourly rate. All right, so if you're paid $20 an hour and you work 3 overtime hours, those 3 overtime hours, you're going to make $30 an hour instead of $20 an hour. And under the new tax law, you won't be taxed on the overtime part of it. So that should, I know the times I've gotten overtime, I liked how my paycheck looked when I got overtime. I bet it looks even better now that part's not being taxed. Has anybody ever gotten a bonus? Or gotten promised a bonus by your employer? And then you got your paycheck and you're like, what happened to my bonus? Like, wait a minute. They don't tell you when you get a bonus that it's going to be taxed, right? I don't know if that changed or not, but I remember being disappointed at my first bonus check. Back to overtime for a second. Employees are divided up when it comes to overtime into two categories. You're either eligible for overtime or you're exempt from overtime. The reason I want to highlight this for you is if you are an employee who has been labeled exempt, but you're actually not exempt based on your duties and the definition of what should be exempt, you need to know that you might be entitled to overtime. Another way of saying that is don't just take your employer's word for it that you're exempt. You need to make sure that they're not mislabeling you. Because there's a big difference between your base salary and what you might make in overtime. Employers have an incentive to misclassify you. And not to say that most employers don't go around saying, I'm just going to blatantly break the law and classify these people wrong. But I'm talking more about the gray area folks where there might be an argument either way. Employers have an incentive to try to find a way to make sure that they classify those as exempt. If you're an employer, you need to be very careful that you have classified your employees correctly. If you misclassify an employee as exempt and they're not exempt, and they come back after you later on for all this back overtime, you could be liable for that plus some penalties. All right, so you want to make sure that all your employees are labeled correctly. Yes, ma'am.
I worked on a project out of Georgia, but we had worked in California for 3 years. For 3 months, and we got the overtime in California. So if you work past 8 hours a day, you got time and a half. If you work past 40 hours, you got double.
So while you were on the job in California, you were subject to California state law. And California state law would be over and above what we're talking about. And you're saying above, not just above 40 hours a week, it's above 8 hours a day.
Yep. And then for 40 hours in the week was
double. So so California is, I guess we would say more worker friendly. I don't know how that balances out with their taxes and how everything else goes, but just isolating minimum wage and their overtime laws, they're a lot more favorable than they are here, for sure. That's interesting. The distinction in classifying whether an employee is exempt or non-exempt has to do with the nature of their duties. All right, so people who are exempt are usually managerial. They exercise a good bit of discretion. Their primary duty is management. They're paid a salary. They have general business functions. They exercise independent judgment. More of what you would expect out of a manager. But there's not a list that goes by job title that says if your job title is this, you're exempt. If your job title is this, you're not exempt. It's an examination of duties. So you can see where that would get a little bit muddy and that there could very well be, envision, let's say I'm hired to work at Starbucks, and I start out at Starbucks as a barista working the front desk. I'm making coffee. I'm an hourly employee, but over time, let's say I've been there 3 or 4 years, and the manager trusts me. And as I've grown in experience, they've given me more responsibility. I'm now opening and closing. I'm doing stuff with money. I'm making decisions about, maybe I'm hiring and firing people. Okay, I started out as someone who is not exempt from overtime, but over time I morphed into more of a managerial role to where I really should have been exempt from overtime. Did I say that right? So you just have to be very careful about how you're classified as an employee, and then if you're an employer, how you're classifying your people. We skipped over child labor. I'll go back to that real quick. Children under 14 can only work in very limited occupations. Under 16, you cannot work full-time unless you're working for a parent. And then children under 18 can't work in dangerous jobs. The reason I don't spend too much time on that is because every state has pretty heavily legislated their child labor laws, and so that every state's going to be very different. I'll tell y'all a story that shows how old I am. I grew up in Cook County, Georgia, and our primary economic engine in our county was that we grew tobacco. And all of the boys, the high school boys, in the summers, we would crop tobacco. They'd come around and pick us up in the truck early in the morning, and they'd drop us off late at night, and we'd be covered in tar. And one year, we actually delayed the start of school by 2 weeks because the tobacco crop wasn't finished being harvested yet. So our whole school system had to wait on the boys to finish their job in the fields before we could go back to school. That makes me sound really old. I'm not sure why I told you that. It makes me feel good about myself. Family and medical leave. Talk about that for a second. So federal law says in this country that every employee is entitled to take 12 weeks of leave per calendar year for certain reasons. Okay, those reasons are to care for a new child, newborn, to care for an adopted or a foster child right after it's adopted or it's placed as a foster placement, to care for a seriously ill spouse, child, or parent, so close family member, to care for themselves if that employee himself or herself has a serious medical condition, or to deal with any non-medical emergency arising out of a family member being on active duty. Maybe my wife is active duty, she gets deployed, and all of a sudden I need to take medical leave, family medical leave, to care for our kids because she's in Iran. All right, so those are all the reasons, the legitimate reasons you can take leave. And that sounds good, and family medical leave is a good thing. It keeps employers from firing people who have legitimate needs to stay out of work. Like I get cancer, I need to get chemotherapy, I need to be out of work. It protects me from losing my job, right? So family and medical leave says you can take 12 weeks, and at the end of those 12 weeks, or if it's shorter, when you return to work, you are guaranteed your same job or a similar job. Okay, that's a very important distinction I want you to hear. It doesn't say that they have to restore you to the exact same job. It's the same or substantially similar. The employer cannot cut off your health insurance while you're on medical leave, family medical leave. All right, so you're guaranteed that your insurance will continue, and that when your leave is over, you can come back to the same or substantially similar position. The downside of family and medical leave is, anybody know what the downside is? What is it, Christian? It's not paid. We're one of the few countries in the world that has unpaid family and medical leave. Your discussion question for this unit asks you to read a very short New York Times article on how we do it in America versus how other countries do it. And your discussion question is, what do you think is the right balance between how long a person should be able to take family medical leave and whether or not it should be paid? I see both sides of that. As an employee, it's going to be hard for me to. I mean, I'm grateful for the leave. I'm grateful for the insurance, but I don't know how I'm going to continue to pay my bills without a paycheck, right? I'm glad to be home to care for my wife or care for myself, but that's not helping my bottom line any. So I get from a social standpoint how society might want to protect workers in that way. As an employer, as a small business owner, I don't like the idea of having to pay employees who are out because I run on very thin margins. I'm not a huge company. I don't have a big profit margin to play with here, right? Let's say if I'm a 15 employee outfit, I can't afford to have 5 people out on medical leave while I'm paying 5 replacement people. If I'm being cynical, the other reason I would not be thrilled about paid family and medical leave is that if we all got guaranteed 12 weeks of paid leave a year, Elrod, how many weeks is everybody taking a year of paid leave? 12, right? I think that would become baked in an expectation that everybody's going to find a way to find 12 weeks of medical leave. Big companies, I can see how that would be easier to absorb. Smaller companies, I can see where that would be a hardship. Yeah, well, and that's kind of what your discussion question asks. What other ways are there that we could do it? Maybe you're not getting your full paycheck, but you're at least getting enough to keep the lights on or something like that. Maybe it's paid, but there are stricter rules for it. Maybe it's tiered where, if you're in intensive care, I mean, you clearly can't come to work. Maybe you get more than if you just are babysitting your grandbaby because I don't know. I think that would, I worry that would become an automatic 12-week paid vacation every year for everybody. Your discussion question also asks you to think about the number of weeks. 12 weeks is also pretty low in compared to some other of the developed world in terms of how many weeks they give you. Yeah, I mean, you can't just email HR and say, "I'll see you in 12 weeks." I mean, so I am being. I mean, I don't think it'd be as easy to take advantage of as I'm making it sound like. But I think people would find a way. I mean, I think if I needed a doctor's note to say that I need to be out of work, I could find me a doctor's note to say I need to be out of work, right? I would hope so. I mean, you look at like the doctors that make all the money off the pain pills. I mean, they're writing prescriptions from people going in there and just saying, my ear hurts. Yeah. So as the owner yourself, if you're the owner, you can take whatever time off you want. These laws would be for employees. I should also mention, though, that these laws don't kick in. They cover employers once you hit a certain number of employees. So, like for me, I have 1 employee. I'm not required to give my assistant family and medical leave. The reason for that is if I'm a small business, I have 1 employee. I can't pay 1 employee and then I can't pay 1 employee to be gone and then have to hire a whole nother one. It just doesn't work for small businesses. So the threshold is, I think it's 10 or 15. I mean, it's a little bit higher than some of these federal laws have different thresholds. Some of them I think maybe 50, some of them maybe more than 10. And then some states can come in and make lower thresholds too. So it kind of just depends on what state you're in. That's a good question. Any questions on family and medical leave? Oh, back to the point about the employee being guaranteed a similar position. You can see where that would spawn some litigation, right? If I'm an employer and I got this employee who went out on family and medical leave and it was legit, but it would be really nice when they came back for me to put them in a different spot. Maybe I don't love how they did their job, or maybe, I don't know. I might have incentive. Maybe the person that covered for them while they were gone did a jam up job, and now I need this person to do something different. We could argue about whether or not the position that they were awarded or given when they returned is substantially similar. If we had a disagreement over that, who would decide that? We go to court. Who decides whether the jobs are substantially similar? The jury or the judge, right? So there's not some computer program that we plug it in and it spits out whether or not the job is substantially similar or not. It just depends. If let's say that I am making $50 an hour, I take family and medical leave, I come back 12 weeks later, they put me in not my exact job, but a pretty similar job in terms of duties, but they're now paying me $48 an hour. Is that substantially similar? I mean, I don't think so, right? But you can't just go by the raw number. That's $2 less. If I'm making $1 million a year and they offer me a job when I return from leave that pays $999,000 a year, that's percentage-wise not as big as the $2 off the $50. So it could depend. And we could argue about what's substantially similar or not. And if we disagreed, again, we'd have to fight it out in court. Yes, ma'am. Both in compensation and in job duties. It's substantially similar in terms of employment. So it could, maybe it couldn't be something like same hourly rate, exact same job, but less benefits. I mean, that might not be substantially similar. Could just depend. So you ever take family and medical leave and you come back and they have you in something different, you just need to know that the law says that it has to be substantially similar, and you should drive a real hard bargain on what is substantially similar or not. They could restore you to your exact same title and duties and pay, but have added more duties. I mean, there are a bunch of different ways that it could be different than it was before you left. All right, health, safety, and income security. So the Occupational Safety and Health Act, OSHA, is the acronym for that law. We confuse that somewhat with OSHA, which is the acronym for the Occupational Safety and Health Administration. That is the executive agency that carries out OSHA, the law, right? And these are the folks that promulgate all those rules. Remember, they are engaged in lawmaking through rulemaking because they're an executive agency, administrative agency. They're the ones that promulgate all these rules about the amount of weight that a ladder step can bear, or the space between rungs on a ladder, the type of headgear that must be worn in construction zones. We could probably I probably should get one of these, the construction foreman here to give us a tour of their project and go over all the hidden places where we might realize that there are OSHA regulations at play. I also wonder how many OSHA violations are going on. Maybe, hopefully not, but it's a big project and it's a lot of people. And I just look around, and I guess as a lawyer, I'm always looking for I just always think about liability for some reason. Speaking of, this is off the topic, but has anybody seen that new bike park on 13th Street down there by Jarfly? Y'all know, anybody know what I'm talking about? That is a negligent, that is a lawsuit waiting to happen. I cannot believe somebody in the city signed off on that. It doesn't have any signs. There are no railing. Like, it's all the, if you haven't seen it, it's all these, what's the word I'm looking for? Yeah. It does. It looks like a gerbil cage. You ride through tunnels, you ride through all these, you got all these wooden things that it's kind of, I guess it's like a skate park, but for bikes. Maybe that's the best way I can describe it. But to me, it just looks like a lawsuit just waiting to happen. I mean, what happens if somebody goes in the middle of the night and removes some of the planks of the boards? I mean, are they having somebody come around every morning and inspect that bike park to make sure that nothing got damaged overnight? I guarantee you they're not doing that. Anyway, back to occupational safety and health. Just know that if you have over a certain number of employees, if you're engaged in manufacturing, you have warehouse, construction, all those things, OSHA is going to apply. Many of your workplaces, you'll see in your break rooms, there'll be OSHA posters. Look in your break rooms too. You'll see not just OSHA posters, but posters about your rights in terms of wages and hours and that kind of thing. Employers are required to post those kind of notices, and often that's where you find them. Workers' comp. So every state runs a workers' compensation system. It's not a federal system, it's state by state. And what it says is that if you get hurt on the job, and it's unintentional, you can't intentionally hurt yourself to qualify. If you get hurt on the job, you can get paid by workers' comp. That's your that is one way that you can get compensated for your injuries. It is a trade-off, however. If you elect to use the state's workers' compensation laws, they don't ask you any questions about fault, or they don't look into it. It's basically, did you get hurt and were you on the job? Okay. If that happens, you qualify. The trade-off is that you cannot sue your employer if you take workers' comp. You have that, and the employees have that choice. You could either go through the workers' compensation system, get your medical bills paid, whatever, but you're not going to be able to sue your employer and recover. If you want to sue your employer, you are free to do that, but you can't access the workers' comp system. So it's a question. If you're ever seriously injured and you think that it was your employer's fault, and it might be something that you could get compensated a lot higher than the workers' comp, then you'd have a decision to make about whether or not you wanted to sue or whether you wanted to just go through the workers' compensation system. You got to take a drug test pretty soon after your injury, right? You see all those labs, that's a lot of what they're doing is giving people drug tests after they're injured. You do have to, because if you come back positive that you were impaired, then you're not going to be eligible for workers' comp, right? So it could be, in other words, it could be an accident. You could get hurt on the job and it's your fault because you were clumsy, but it can't be your fault because you were impaired or you intentionally did it or something like that. Income security, I want to spend a lot of time on that. This is if you ever look at your paycheck and you look at all of the withholdings, these are all because of our federal income security laws. That is where they are deducting your Social Security. You're contributing to your Social Security account. You're contributing to your Medicare account down the road. You are contributing to your tax withholding, both federal and state. Your employers are paying unemployment insurance on you. All these deductions. I'm sure everybody's had this experience. The first time you got your paycheck, in your mind, You were expecting to see your hourly rate times the number of hours, right? You were excited. In your mind, you're like, I've just worked 10 hours at $15 an hour. I'm fixing to make $1,500. I get my paycheck, 900. Like, where's the other 600? Then you flip the page. You're like, I don't even know what these numbers, these letters stand for. Where's all this going? It's going to the government through a lot of these income security laws. COBRA, I want to mention COBRA to you. If you lose your job, the employer is still required to offer you health insurance, but you have to pay for it. That just guarantees that you can't be fired today and then not be insured tomorrow. It guarantees you access to continuing healthcare coverage, just that you have to pay it. Most folks who lose their job and lose their stand to lose their health insurance will go out and buy insurance on the private market. It's usually cheaper than COBRA. But, let's say I have cancer and I'm undergoing cancer treatment and I lose my job, legally lose my job. I'm going to want to stay on COBRA because I don't want to be uninsured and I don't want to risk going out in the market and trying to get insurance from somebody and having to tell them I'm actively undergoing cancer treatment, right? I may not qualify for my pre-existing condition. So COBRA guarantees an employee the right to continue to access the same health insurance. It's just at the employee's cost. So my 11 o'clock class, I've got a online student who's coming to make a short presentation, and that I'm not going to assign to y'all. So in order to keep y'all on track with my 11 o'clock class, I think I'm going to stop here for y'all. We'll just stop early today. If you came in late, y'all don't go anywhere yet till I can get everybody that came in. Chappie, got you. Mr. Bernard, got you. Battistini. Tell me your name, sir. Eason. That's what I thought it was. Did not see Dunn. Hoffa, I got you. Anybody else? Mr. Wright. I think that's everybody. All right. Ms. Hackett, you were gone. I'm stopping early because I got to keep y'all on the same schedule as my 11 o'clock, and they've got some extra they're doing. So see y'all Tuesday. Remember, you have a quiz due Monday on Unit 8. We're almost there. Yes. Okay. That's what I was seeing this morning. What is Seattle? $30? Oh, $21.30? I wouldn't open a business in Seattle. I couldn't afford to pay my employees.
I'm at like $10 an hour.
I remember, I actually had a job in college and I was paid $7.25 an hour, folding towels at the Y. Yes, sir.
Oh, I just went about the we print out the interview.
Yes.
So turn into the career center.
No, I want you to turn that into me.
Okay.
Just scan it and turn it in.
Email it to you or just
Yeah, you can email it to me, or you can attach it to the assignment. Yeah, that works too. Okay. Or attach it to the assignment is probably the easiest way.
All right.
Yeah.
No computer guy.
All right. Did you get your appointments made?
Yes, sir. I did mine. Tuesday.
Oh, you already did it?
Yes.
Okay. How'd it go?
I didn't really gain much from it. I'm not gonna lie.
You didn't? Oh, no, that's the kind of feedback I want to know.
She did say she knew she was going on.
Who'd you have?
Jade Colson.
I do think it depends somewhat on who you get.
She sounded like she was nervous to talk to me, kind of.
You were interviewing her?
Pretty much. I could.
I'm sorry. I don't want anything y'all do to be a waste of time, but at least you get your resume in shape.
Yes, sir.
Okay.
I'm back-to-back performance.
Okay. I do think that's worth it.
Yes,
probably something you wouldn't have done on your own. So, all right, good deal.
All right. Thank you.
All right, yep, y'all take care.
Washington
1713.
So it's the second highest.
Second high. Okay, that's right. So both the Washingtons are highest. Okay.
And some of the cities in Washington State are over 20.
Jeez. I don't know how I would operate a business in